A very good evening, viewers. It's good to have you on yet another episode of your favorite program, You and the Law, brought to you by NTA Gombe. With me today in the house is Barrister Japhil, Yila, a legal practitioner here in Gombe, to talk about divorce or dissolution of marriage under the Act. Barrister, you're welcome to the house.
Thank you very much, sir.
All right. Yeah, Barrister, you were here last time and we talked at length about divorce, and we've been able to establish a lot of things, and you've intimated us about certain things that we didn't know about. So now today is a continuation from where we stopped, so that we can establish certain grounds and get to know more about what it entails concerning this trivial issue, which most times we don't want it coming up, that is divorce. So we're going to start by asking the barrister, can divorce be, you told us the last time that there are certain things that have to be established, about 8 of them, that before divorce will be granted to either partners who brought in the suit. But can divorce now be granted to a petitioner on the establishment of 1 or 2 and not all 8 of the grounds for divorce?
Yes, it can. As I've said the other day, by virtue of Section 15 as well as Section 16 of the Matrimonial Causes Act of 1970, the provision therein lies all the ingredients needed to establish a case of divorce or dissolution of marriage. But it must be made very clear here that just one of the grounds there is sufficient enough to call for dissolution of marriage if you can prove it perfectly well. Yeah, the consummation of the marriage, if you can establish the facts, evidence that there is an issue, that is the fact that the marriage has not been consummated, is a very good ground to dissolve the marriage. And I think above them all should be adultery. If you can establish the case of adultery perfectly well, it's okay. And that goes for the rest of the other jurisdiction, like under Islamic law, in fact, customary law, the Christian marriage. If you can establish that there is a case of, if the petitioner can establish the fact that there is adultery, there is a case of adultery on the part of any of the parties, the spouse, it's a very good ground for the marriage to be dissolved.
All right. Now, thank you so much for that input, Barrister. You told us last time that divorce doesn't come easily. The court will not want to see couples separated, so most of the time they give room for reconciliation. They tell couples, as you said last time, to go and reconcile and see whether they can meet up their differences and go back home and stay together. Now, during the course of this reconciliation, I believe a lot of facts and evidence will be brought up in order to, find a common ground where they can settle. If there be forgiveness here, reconciliation, here and there. But I come to understand that barrister, that during the course of reconciliation, and in the event after that reconciliation, the couple decide to go on with the case of the divorce and come back to the court that we've not settled. I understand that the anything admitted during the course of the reconciliation cannot be used as evidence in the court. Why is that so, sir?
Well, yes, as you have rightly put it, the court usually are lenient when it comes to the issue of a dissolution of marriage. If couples decided, okay, we want that reconciliation, because most of the times the court will say, I think there is still an opportunity for you to go and reconcile this marriage if possible. So if it fails, and they decided to come formally before the court, then it's okay. And when they come formally, they have to front load the process, because during reconciliation mostly is oral presentation. Now, if they decide to come formally before the court, then they have to come via front loading, where they have to write everything down. There will be the petitioner's argument, and there will be the respondent, response argument too. The petitioner will give reasons. He will write down the reasons why this marriage should be terminated, while the respondent will say, no, these are my reasons, this marriage should not be terminated. And in the course of the proceeding, fine, whatever was discussed during reconciliation can change. It's okay. You can put it, maybe certain things that was admitted in the course of a reconciliation, when front loading in the proper court, can be changed and put in such a way that is going to benefit the petitioner this time around, or the defense that is going to benefit the respondent this time around. Okay, for instance, during reconciliation, a respondent may likely admit certain facts, whether true or false. But okay, in the course of peacemaking, let peace reign, decided to admit, so that he can gain favor from the petitioner.
The petitioner, yes.
And if that happens, then fine. If she forgives or he forgives, then fine, life goes on, they continue with the marriage. But in the event that she refuse or he refuse to admit, to forgive. Then if they come proper before the court, you don't go to admit that, yes, I admit. No, it's wrong. Let him just come before the court and deny it. I did not admit during the reconciliation, so I'm denying it. Whatever she says is wrong. So it's for her to prove that he is wrong. She is right, he is wrong. So it's a matter of proof now. She alleges that he committed, so then let her prove him wrong, that definitely he committed it. And I think the court is okay to say, okay, it's okay for him to deny it, so that let her prove it. Then the court at the end of the day would decide whether there is that alleged offense or not. So it's a normal proceeding. Such is not too common in customary law.
Okay.
Customary law are not too strict about stuffs like this. If you allege a situation and people don't sit down, there is no strictness about it. In fact, you don't even need to even come before the council, as I've made mention earlier the other time. You can just decide to just stay away from the woman. You stay away from her, or the woman stays away from you. It's as equal as there is no marriage there. So it's more easier in most of our African customs and native laws. Under Islamic law, still under Islamic law is strict, because you have to prove it too, that okay, she actually committed adultery. That's why you are leaving the marriage. You don't even need to go to court. I have said earlier, what you do is just pronounce. You have that right as a man. You will just pronounce it. You would pronounce what is called talak, that is a divorce. You pronounce simple in Hausa nasekeki, that is talak the first time. You give some time, you pronounce the second time. You give, because you must make it three times. It's not once. You can't just wake up and say na miki seki there, and na miki seki just once and that's all. It doesn't apply like that. You must pronounce one, give some time, pronounce the second time, give some time, pronounce the third one. Then after that one, there is no way that marriage stands terminated until when she goes and marry another person before you guys can come back and marry together. And under the Christian, there is nothing strict about this divorce under Christianity, like as is done in the courts. Under the Christianity, the Christian doctrine, they sit down and actually analyze how marriage can be divorced. Nothing, just if she commits adultery, okay, fine, you can say let her pack, and she pack. There is no procedure, just no nothing.
All right. Thank you so much, Barrister. Um, Now, there are certain grounds for dissolution of marriage, as you said, ranging from adultery, non-consummation of marriage, so on and so forth. Now, I'm a little bit curious, Barrister. Uh, how easy is it for a petitioner to prove, one, that the accused partner has willfully and persistently, right, refused to consummate the marriage, since this is a bedroom thing for two individuals, and now the petitioner is coming, no, since we got married, this man has refused to what to know me as a woman, and I don't know why the insistence of willfully and persistently, you understand, is coming there, willfully and persistently. And then how is it to to establish that this man has refused to consummate the marriage? That is A. And B, how easy is it for a petitioner to prove that his partner or her partner has committed adultery?
Yes. Well, it's not easy. As I've said it earlier on, it's usually not easy to prove all these elements, all these ingredients in a case of dissolution of marriage. It's not too easy. It is easier for a petitioner under the Matrimonial Causes Act to come under abuse, domestic violence, that the respondent has made life unbearable for the petitioner to stay in the marriage. So petitioner is applying for dissolution of the marriage. It's more easier for you to come, you the petitioner, to come under this particular package.
Yes.
I think number 3 or number 4,
yes,
by virtue of section 15 and 16, as I've quoted earlier. It's easier. But if the case is adultery, honestly, it's not too easy. To prove adultery to the satisfaction of the court to grant you your prayers, it's not easy, because witnesses are expected here. You can't just wake up and say, she committed adultery, that's why I want to dissolve the marriage. You have to come with witnesses, evidences that will prove, evidences that there is a relationship between the respondent with somebody out there, and these are their pictures, these are witnesses that sees them together, these are evidences of coming into this particular hotel. You have to prove all these things to the satisfaction of the court. So it's not usually easy.
Okay.
Under the Islamic law, it was made very clear that 2 adult witnesses must be there. Not only adult witnesses, they must be sane. Not only sane, they must saw the thing, like mortar and pestle. That is tabaria da turmi. They must saw the thing, saw it happening, then they can come and give witnesses that certainly the case of adultery, as alleged by the petitioner, has been proven. We have seen, we are there. So it's not easy. You can't have sexual knowledge with people around there. It's not going to be easy. It's not too simple. So proving it under Islamic law is much more difficult than under the Matrimonial Causes Act. So what we are saying is that proving the case of adultery is usually very difficult. Maybe easier under the customary law. You can just come, maybe one witness is okay, she committed adultery, or he committed, they can dissolve the thing. It's easier under customary law. I don't know about Christian, it's not even law, so there is no procedure for that. So maybe you can just come and say she committed the thing, and anything can happen. Let them just decide. And now, when it comes to the issue of consummating the marriage, still is also about proof, and which is very, very difficult, because same applies to the issue of adultery. How do you prove that there was this particular case in Lagos anyway? Fine, she agrees. because he, as the petitioner, wants to dissolve the marriage because she refused him consistent sexual encounter. When she said yes, there is no argument about it. But the problem here is that she has been sick, and she has always been sick. He did not find time to cure her sickness, but rather he was more to have carnal knowledge with her, that is to have sexual knowledge with her. His problem is only sex, not the sickness. And defense was good. The court considered the thing and said, hey, but now you should have treated her first. She's your wife, and actually your duty. You have to treat her. So that is the thing. Before you can prove, the issue is proof, and you have to satisfy the court that yes, the court will come and say, from all indication, this petitioner is not happy in the marriage, because one of the key elements of marriage should involve the subject matter of whatever sex in it. So definitely he has been deprived of the sex, so he has good reason to. It's all about the court. It's all about evidence presented before the court, and it's all about the decision reached by the court at the end of the day.
All right, thank you so much for that input. Now, in relation to that, barrister, I want to know if a marriage has been consummated already now, and there is a problem now within the marriage. Now the petitioner is accusing his or her partner that now this person is refusing me sex. You know, but we have had 1 or 2 or 3 or even 4 children, but now this person now is refusing me intercourse. Now, on that ground, can the marriage be dissolved?
Yeah, it can be dissolved. It can be dissolved if it means, even if it is 20 children, it doesn't matter, as long as the issue of consummation in the marriage is not there, and any of the party is desirous of the other party to offer to offer sexual relationship, and that is still a ground to dissolve the marriage. But as I have said earlier, everything lies with evidence.
Okay.
You can't just come over the court and say consummation of marriage, consummation. The court will still have to ask a certain question. You are talking about how old is this woman? Can't you see a sexual drive, is diminishing? You don't expect when she was 20 and now that she's 45 or 50. The court will still have to put that to you. Or is it that you are finding ground to just dissolve this marriage, or you want to go and marry another person? What do you want? How do you want? The court will look at the situation. If she's within the category that she can actually offer sex and is okay, she definitely, and she's not ready to, the court will dissolve the marriage. But in a situation where the court have to consider her interest too, if there is a factor that is not giving her room to actually make sex a reality in the marriage, the court will look at it and say, look at it now. It's all about evidence that is presented before the court, and the court does everything possible to do justice both for the parties.
All right, thank you so much for that input, barrister. So, but what are the salient difference between dissolution of marriage under the laws?
The differences are just minor things, and which we have already enumerated earlier in our discussion. The customary law, the dissolution of marriage under the customary law is easier. It's very simple as far as Africa is concerned. All you need to do is just present just one mere thing and just say this is it, and mostly the marriage is dissolved. There are no strict written laws or consequences. There is nothing like that. So it's just simple. It's just simple. I don't like her anymore. It's a ground why you can dissolve the marriage. I saw her talking to her ex-boyfriend. It's a ground to dissolve the marriage in most of the customary laws in Africa. So it's easier. It's easier. But when it comes to Islamic law, it's not too easier, because you can't just wake up as a man one day, I want to dissolve this woman and marry another woman. No, you can't just do it now. You must have reasons why you have to dissolve the marriage. Not because you feel in your mind that you are going to just dissolve the marriage, wake up one day. No, you have to give reasons, and the reasons must be understandable. That this is the reasons why you want to dissolve this marriage, and the reasons has to be reasonable for any average elders in the community, and that is the Muslim elders must approve of this reason. So when you pronounce the talaq, as I've said earlier, if you pronounce it, people will ask, what's the reason for that talaq? You must give them, she did this, she did this, she did, and this is against the teachings of the Islamic injunction. She did what is not supposed to be done by a married woman under Islamic law. So you must give all the reasons. What did she do? They are spelled out there. A woman, this is what is expected of a woman. Once she fell short of those things, there are good grounds for dissolution of marriage. So you see, you must follow what the book spelled out. You can't just wake up on your own and just decide to cut off marriage. Same applies to what do you call it? The marriage under the act, as we have spelled out. Now, marriage under the act still are coded laws, as we have said, section 15 and 16. There are laws there. They were spelled out. Until these things, there is, until certain things are not met up, you cannot just wake up one day and just say, you decide, I want to, dissolve a marriage. In fact, one of the differences, one of the salient difference there is that under the Matrimonial Causes Act, in fact, you cannot come, as I've said the other time, you cannot just come less than 1.5 years and say you want to go and dissolve the marriage. No, you can't just come like that now. Stay in the marriage until it is 2 years before you talk about divorce. It's not so under the Islamic law. Under the Islamic law, you can, in 2 days of the marriage, you can apply to dissolve the marriage because she has fell short in doing those things that is expected of a Muslim woman. Under the customary law, too, you can just wake up anytime and say, she did this, she did this, she did, and I don't like it. So I want the marriage to be dissolved. Now, under Christian marriage, well, that is not law. The only thing there is from time to time, Jesus Christ will one day address the people. Do not divorce your marriage, stay in your marriage. Or unless there is issue of adultery, you are not permitted to, these are the little differences. Customary law, there is nothing like decoded laws. Laws are not written. The law is about the conscience of the people. It stops there. You can just wake up and say, okay, she committed this, this, and this, so I'm not too comfortable. I want to dissolve the marriage. We have spelled that of the Islamic law, the Christian law. These are the silent differences.
All right. Well, thank you so much. Barrister, I want to know, what are the legal implications of already dissolved marriages? The
legal implication is that marriage stands dissolved. That is number one. But the thing, under customary law, it doesn't get dissolved forever.
Okay.
It can be dissolved now, and you may decide on your own to go and remarry her again. Mostly, that is majority of, unless somebody marries her. But as long as she's still there, you can still go back and marry her. Because the law of the customary law is within the conscience of the people. That is one. The legal implication under Islamic law is that when you marry her, when you dissolve her, that is the 3 talaq, and she goes off, you are forbidden to marry her again. She has to go and marry somebody, and that marriage must be consummated. After such, you will dissolve that man, then when she comes back, you can marry her again. That's the legal implication. Now, under marriage under the act, this time around, if you dissolve the woman, there is this period of 2 years that it's a grace for her to either appeal the case or something like that. When that 2 years elapses and nothing was done, then they will that marriage stands dissolved absolutely. So the 2 parties are forever, you know, what do you call it, forbidden to marry again, because as far as that law is concerned, that marriage stands terminated.
Okay.
That is, these are the differences among them. While that of the Islamic law, you can still come back again and marry, but this one, it stands terminated. Customary law, you can marry again. Christian marriage, well, we don't know, anything can happen with that one.
All right. Thank you so much, Barrister. Now, time is really against us, but I know, maybe just in 1 minute. What are the roles of communities in the fostering rampant number of divorce cases? Just in 1 minute.
Well, community should the community should come, because it's getting rampant now. One, preachers, I think parents should help educate their young and able contending couples that wants to marry. They need advice. They need advice on how to stay in the marriage. They should know the implication of staying in the marriage, and they should know the implication of the issue of divorce, the dissolution of the marriage, the implication if that is the disadvantage of dissolving the marriage, the interest of the kids that are in the marriage, and the stigma that is associated, and how do you start the life. These things should be told for any party or two couple that wants to come together and marry. They should be properly educated. Both the elders in the community has a role to play. Cleric men have a role to play. The church, the mosques, have a role to play in their lives, as well as the community and parents, more especially the parents. They should come in. They should talk to them. They should advise them. They should put the nitty-gritty of what this marriage entails, and how they can tackle issues in between them, and how they can do all that it takes to avoid dissolving the marriage, and be told where and when it becomes necessary that the marriage should be terminated, should be dissolved. When you sense danger in the marriage, please stay away from that marriage. I think that's better. If your husband knows how to beat you, turn you to punching bag as it is done now, run away from the marriage. It is important for the lady to be told. And the man also should be told. If you have a woman that doesn't respect you, or at a point in time she doesn't regard you as a man, and you are doing everything possible to make high time you dissolve the marriage. There is nothing about it. There is no do or die affair about it, that you must stay together until one dies. It's not okay.
All right. So thank you so much, Barrister, for that input. So there is always a need not only to say go into marriage, but to tell them beforehand how to settle the problems, and when to go out when it's about to cost life. So thank you so much for coming around, Barrister. And unfortunately, time is against us, and we're going to draw the curtain here. Remember, this program Beyond the Law is brought to you by NTA Gombe. So we look forward to having you next time. Watch our program as we invite our able barrister and more barristers to come and give us more education concerning you and the law. So until next time, do have a pleasant evening.